Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, I'm Gatan. I'm majoring in Law Class 1B, and here I want to read Unit 3, Marriage Law Reforms. Major portion of the statutory personal laws enacted in various Muslim countries represent a mere codification of the established law, or at best, unification of hitherto divergent legal principles. There is, however, no reason to deny the fact that certain provisions in these laws have introduced significant reform in the traditional law. The principal reforms so introduced in one country or another relate to: A. Marriage age for men and women, and difference of age between parties to marriage. B. Role of marriage guardians in fixation and examination of marriage. C. Registration and documentation of marriage. D. Monetary aspects of marriage, dowry and expenses. E. Polygamy and rights of co-wives. F. Maintenance of wife, family, and matrimonial home during the subsistence of marriage. G. Unilateral divorce, rights of parties to marriage, and grounds for judicial divorce. H. Post-divorce, reliefs for the parties, especially for women. J. I. Period of gestation and its implication. J. Parents' rights relating to custody and guardianship of children, especially of mothers. K. Inheritance rights of certain close relatives, surviving spouse, daughters, brothers, sisters, grandfather, and descendants of predeceased children. L. Choice of the legatee, especially their eligibility to receive a bequest. And M. Validity, tenure, and management of family WAPs. Reforms in these areas have been effective. Different reforms in different countries, either under the provision of comprehensive codes or laws, or personal status or family rights, or by way of sporadic legislation. The source materials for all the proposed reforms have been located by the jurists and legislators of the Muslim world in the depth, divergence, flexibility, and richness of the legal principles within the vast framework of the Sharia. It is nobody's case in the Muslim states, including Turkey, that personal law has been codified and reformed merely to modernize or westernize the law. Nor have their architects, advocates, and exponents ever quoted any wholly un-Islamic source for any of these reforms. The motives behind and the objects of all this legislative activity have been, as told by the reformers, the need to systemize personal law on the pattern of other law since codified, the desire to benefit from lesser unknown and hitherto neglected principles and juristic opinions within the fold of the Sharia, the will to check misinterpretation, misapplication, and growing misuse of the Sharia law, of which there were greater chances and possibility in its uncodified state, the policy of nationalizing and truly Islamicizing the law, and the urge to rebuild the society in conformity with the original, unalterated socio-legal principles of Islam. In several countries, the ulama have approved or have been closely associated with the reforms effected. At the same time, some of the reforms in some countries have been opposed and criticized by certain sections of religious leaders and scholars. This has happened in Iraq, Indonesia, Pakistan, Tunisia, South Yemen, and Turkey. On some occasions, their objections were accepted and the reforms proposed are already effected, dropped, repealed, or modified. Measures Tahir Mahmud, 1987, Personal Law in Islamic Countries, History, Facts and Comparative Analysis, Academy of Law and Religion, New Delhi, pp. 11-13. Okay, I think that's all. I'm sorry if any mistake. And yeah, Assalamualaikum warahmatullahi wabarakatuh. Bye.